How can inheritance impact divorce settlement? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Can inheritance impact things? Well, they can to some degree. Let me first tell you how it impacts the overall marital estate. You have to remember one thing. The marital estate is designed to address those assets that have been accumulated during the marriage. It could come from work. It could come from investments that you've made. Could it come from an inheritance? Well, the law has a very distinct way of setting it up so that inheritance is always kept separate, because the person who died, who left the inheritance, might have done so at a time when the people weren't even married. For all I know, wills and stuff may have been drafted, when the parties to this divorce were 5 years old. So clearly, you can envision a situation where the one who dies, who is leaving the inheritance, never contemplated that it should be split with some spouse that nobody even knew. But you have to understand one thing. Because of that, the law is pretty clear that if you get an inheritance, it's separate property. So long as you keep it separate and you manage it separately, it's not going to be part of the divorce equation. However, if you don't keep it separate, if you don't manage it as a separate and distinct asset, but if you commingle it with the marital asset, let's say you take the $100,000 that you've inherited and you put it in your joint bank account with your spouse. There's a strong argument to be made that what you've done is you've made a gift to the marriage. You've commingled a separate asset. You've now made it a marital asset, and you can expect that it's going to be in play. Years down the road, when they look at that account, they're not going to say, oh, we're going to take $100,000 out of it plus interest because that was originally funded by your inheritance. And then the court's not going to do that. The court's going to look at what's in the account and split it. Which means if you expect it to be separate asset, you got to treat it as a separate asset. You've got to keep it as a separate and distinct piece of property. Now, can it impact the divorce settlement as an overall proposition? Well, it can in this sense. Let's say it's kept separate. Let's say you got a $500,000 inheritance and that's kept separate, and now you've got the marital assets that you're dividing up. Well, a mediator may look at what's separate and may look at it like this. The mediator may say, look, yes, that's a separate asset. She's not taking a piece of it and you're getting all of it. But it does create a different financial picture. It creates a financial picture where you will better be able to recoup from the divorce, where the other person who doesn't have that $500,000 might not be able to. So therefore, the court might look at that and say, you know what? Without that asset, you might have been a candidate for some alimony. In light of what's going on, all things being equal, it would be inequitable for us to give a big alimony award at this time. Or the court, they may say, you know what? Yeah, you'll get some alimony, but in light of the fact that you're getting that asset, why don't we cut the alimony from $1,500 to $500? Because the truth of the matter is you have a way of financially recouping that the other side doesn't have. So it won't necessarily impact what's included in the marital estate, but it could be used and considered when we look at other issues and when we look at whether or not the parties will be able to financially recoup their position after the divorce. If you have any questions about your case, reach out and we'll be glad to help you out.